In this episode, we'll discuss the tension of the NFA. Is it a tax or a regulation? If you take nothing else from this video, here's what matters. The Senate parliamentarian said that the repeal of the NFA couldn't be included in the one big beautiful bill because it's a regulatory, not fiscal matter. When challenged in court, it's been argued that it's a tax. Yet in Congress, it's considered a regulation. Confused yet? Because it can't be both. There's a tax not tax paradox with procedural contradictions and doctrinal instability. At the core of the current controversy over the NFA is a striking internal contradiction, one that exposes the fragility of the law itself. In a recent procedural ruling on the One Big Beautiful Bill, the current Senate parliamentarian determined that repealing provisions of the NFA, targeted by the Hushing Short Acts, could not be included in a budget reconciliation package. Her reasoning was rooted in the Byrd Rule, which limits reconciliation to provisions whose primary purpose is fiscal. Repealing these taxes, she concluded, constituted a regulatory change rather than a budgetary one. On its face, that judgment appears consistent with Senate rules. But it collapses under closer legal and historical scrutiny, particularly when viewed in the context of how the NFA was originally justified and how it has been defended in court for nearly a century. The NFA is a taxation workaround, not a regulatory mandate. When the NFA was enacted in 1934, Congress was not operating with a robust doctrine of federal police power. There was no established constitutional authority to ban specific types of firearms outright. As Attorney General Homer Cummings acknowledged at the time, the legislation was framed as a tax precisely because a direct prohibition would have been politically unviable and constitutionally questionable. Cummings explicitly stated that the bill was structured to operate as a fiscal measure, not because taxation was the principal aim, but because it was the only available avenue. Indeed, the law was not placed in the criminal code, but codified entirely within Title 26, the Internal Revenue Code, alongside statutes governing excise taxes on alcohol and tobacco. The core mechanism was a $200 transfer tax, an amount designed to deter ownership through economic exclusion. At the time, the sum exceeded the cost of most firearms and was roughly equivalent to $5,000 today. The accompanying regulatory structure, fingerprinting, registration, approval, was not justified on independent constitutional grounds. It existed solely to support enforcement of the tax. When the NFA reached the Supreme Court in United States v. Miller in 1939, the government did not defend the law as a valid exercise of federal regulatory power. Instead, it relied on Congress's taxing authority under Article I. The court accepted the framing, and future judicial treatment of the NFA was largely proceeded on the same basis, as a tax statute, not a criminal prohibition. At no point in the statute's legislative history or its judicial defense was the Commerce Clause invoked as justification. In this light, the parliamentarians claim that the repeal is impermissible because the NFA as a regulatory matter presents a doctrinal sleight of hand. The NFA was always a workaround. Its constitutional legitimacy hinges entirely on its fiscal character. If the law is now recharacterized as regulatory, then its original justification as a tax is no longer valid. That makes the entire structure of the NFA constitutionally indefensible, because it imposes restrictions on gun rights without any valid historical or fiscal foundation. This creates an unstable loop of legal logic. On the one hand, the NFA is framed as a tax to survive constitutional scrutiny. On the other hand, when lawmakers attempt to repeal it through the budgetary means they have access to, on the very grounds that define it as a tax, it is recharacterized as a regulation, making it ineligible for inclusion under a budget reconciliation bill. Simply put, the law is a tax when challenged in court, but a regulation when challenged in Congress. That contradiction doesn't just violate legislative coherence, it undermines the law's legitimacy. The Senate parliamentarian, in trying to protect the NFA from repeal on procedural grounds, inadvertently reinforces the point that critics have made for years. The NFA exists in a kind of constitutional and procedural limbo, surviving only through selective framing that shifts depending on which branch of government is scrutinizing it. The parliamentarians' decision to permit Congress to reduce the NFA's tax to zero, though, adds another layer of instability. If the tax can be eliminated via a simple majority vote, but the surrounding regulatory structure remains intact, registration, fingerprinting, background checks, delays, then the law becomes a legal Frankenstein, a tax statute without a tax, enforcing regulatory burdens that lack a revenue justification. There is no historical analog for such a scheme. Founding-era laws did not impose enforcement mechanisms divorced from a fiscal core of a tax. And under Bruen, text, history, and tradition was formed as a test. A taxless enforcement regime that burdens the exercise of a fundamental right without historical precedent is legally indefensible. There's a case for judicial intervention. This procedural imbalance cannot be ignored. If Congress is permitted to zero out the tax but not touch the regulatory provisions via reconciliation, it splits the statute in half, preserving its burdens or removing its fiscal rationale. That undermines the logic courts have used to uphold the law. The regulatory components can no longer ride the coattails of a tax whose legal significance has been erased. The result is a statutory regime that burdens constitutional rights without fiscal justification, historical precedent, or doctrinal coherence. It is this kind of fractured legal structure that Bruen demands be struck down immediately. For this reason, the Senate parliamentarians' decision should be cited directly in litigation challenging the NFA that's currently making its way through the courts in Bruen v. ATF. Though procedural in origin, the ruling reveals critical truths. The NFA is, at its core, a tax statute, that its burdens remain even when the tax is nullified, and that this internal contradiction reveals a broader constitutional instability. Plaintiffs in Bruen v. ATF should treat this ruling not as legislative trivia, but as real-time proof of how the NFA has become unmoored from both its constitutional justification and its fiscal origins. The parliamentarians' decision unintentionally exposes the NFA's greatest vulnerability. It is a law that no longer knows what it is. In that confusion, fiscal in courts, regulatory in Congress, burdensome everywhere, should not shield it from either repeal or judicial review. How Bruen v. ATF will ultimately be decided remains to be seen. But what's already clear is that the case raises foundational questions about the National Firearms Act, its history, and its legitimacy. This channel will continue to explore the legacy in future episodes, including deep dives into how the NFA came to be, how it's been enforced over time, and how it fits within the broader landscape of federal firearms law.